in international legal disputes, meeting legal experts, attorneys and solicitors at the US Federal Court and District Court of Chicago, USA as part of interactions with the International Bar, an initiative that received wide appreciation. We welcome you, sir. I would like to invite Dr. Pooja Paul ma'am to give a brief welcome to sir.
Particularly speak on both the topics, but I have got the privilege of my associate who has been one of the lead officers in intellectual property rights, and she has heard so many petitions being in the capacity of judge deciding, and I think on that aspect we will be having the privilege and opportunity to interact with her also. Now, as the first topic, which is about the career pathways in alternative dispute resolution is concerned, this is one of the wide field in today's practicing era. If you will see what is the ultimate requirement for any developed country, one of the requirements of a developed country is to find out the ways and to find out the ways of conducting the business smoothly, having a proper dispute resolution system in the form of traditional courts. But as you have seen throughout the world, the traditional litigation world, particularly in the context of commercial litigation, was becoming very burdensome. Having years taken to decide the commercial disputes, even small commercial disputes, were somewhere making the entire business world concerned about the growing needs of resolving the disputes quickly and swiftly. Having confronted with these kind of hurdles being faced by the international community and some of the developed nations, one of the consensus that was reached to evolve a alternative dispute resolution system, and that was evolved with the help of some of the mechanism which came out in the form of arbitration, mediation, conciliation, and certain other allied mechanism locally associated and available with the countries. So right now, while India, in terms of finding out the pathways, giving alternative dispute resolutions also evolved, and at present the alternative dispute resolution system, particularly I am speaking in the context of India, and minorly if I am zeroing down in the context of Delhi, I can see in Delhi High Court, DIAC, Delhi International Arbitration Center, which is one of the prominent institution right now, which is taking care of international disputes, and one of the all amenities fulfilled building S block in Delhi High Court is continuously regularly functioning, wherein the retired judges of High Court and Supreme Courts are dealing with the cases and the issues involving millions and billions of rupees and other serious issues. Even I have got the opportunity, I am also appearing in various matters of arbitration, which is part of the alternative dispute resolution. So while speaking the pathways, so alternative dispute resolution in this form, particularly in the shape of arbitration, is one of the prominent career pathway that can be chosen in the shape of becoming arbitrator, practicing lawyer, or the associated allied ways in which one can associate it with, like being researcher, facilitator, paralegal advisor, and paralegal assistant in a law office. So any form of, this is the first branch which I am talking about of the arbitration. So arbitration starts from initial stage of any business transactions. If particularly if you will say two business entities when they are entering into, one of the clause that is given to entering and resolving dispute through arbitration is one of the pivotal mode of settling the disputes which may arise at any time. So if that mechanism is adopted by the business communities or any other associated concern while dealing with any of the dispute, any of the business transactions, any transaction related to even business, they have been given the facility, they have been given the option to adopt the arbitration. Even one of the dispute, concurrent dispute that I would like to share with you, one or two of the election petitions concerning the lawyers came out, and where the election even of the Bar Association was challenged. But there was one of the clause in that also, that of alternative dispute resolution to the election tribunal and other disputes. So in other ways of finding the other ways apart from the traditional litigations, ADR is one of the role-making pathway, not only in terms of resolving disputes, but one of the option for the career as well. So I have given you the example with reference to arbitration that can start from district court by way of appointment and depending upon the magnitude of the amount involved. District court arbitration, you can have a sole arbitrator in the form, and depending upon the amount involved, district court's jurisdiction can be invoked while you are going the appeal under section 34 of the Arbitration Act. While the higher magnitude of amounts are involved, then you have got one of the options of involving the state level arbitrations which are sponsored by the states that I have already told you about, the DIAC. Even some of the private institutions have also come with the arbitration, where they are providing the facilities of conducting arbitration with the help of their arbitrators. Some of the societies emerged previously before the establishment of DIAC in Delhi. So those private societies also played one of the pivotal role before the establishment of this DIAC in High Court. So now not only the government legislation or the other allied institutions have taken deep and keen interest to establish the alternative dispute resolution, but also the stakeholders, whether those are the businessmen and other entities which are keenly interested in resolving their disputes, swiftly are also taking these pathways which are giving opportunity to law students, professionals to associate with and deal with and connect with in different modes. So arbitration I have talked about it. Now thereafter mediation. Mediation is also playing one of the very significant role, why not only in traditional litigations but in commercial disputes also. Sometimes in the agreements which are entered between the entities, you will find the incorporation of the clause of the mediation. So mediation right now also, if you can see all over India, the Delhi Legal Services Authority have set up various entities of mediation. Even if you will see the Commercial Act that has emerged in the year of 2013, and in the Commercial Act the amendments were carried out in the year of 2018 and 19, through which one of the important and the necessary mandatory clause was made of pre-institution mediation. So pre-institution mediation is one of the mandatory requirement for institution of any commercial suit. If you have not incorporated, you have not availed the mediation, pre-mediation litigation, you can't file. The suit will be barred under section 12A of the Commercial Disputes Act. So because initially in the field of predation litigations, there were no requirements of pre-mediation, so lawyers were also not aware of this mandatory requirement which was there in the shape of Section 12, mediating essential and providing essential requirement to go for pre-mediation litigation, mediation. Even one of the cases we dealt with, one of the interesting stories that I will be sharing with you with regard to pre-mediation, we find one of the case, namely SRD Overseas versus Deepak Gupta and other. This is the case which I am sharing with you of my office, in which we initiated one of the pre-mediation, pre-commercial mediation, and somehow there was some confusion with regard to the jurisdiction point north and northwest. So we, suppose I am just taking to imaginary date, we filed a case online in the month of April 2022. 2022 after Corona phase, so many litigants and the court staff and the professionals were not aware of this mandatory requirement which was there in the Act. So we filed that case online in the April, but somehow we got to know that our mediation was done in a different district, that was northwest. So we thought that because we have availed the facility of pre-mediation as per the provisions of Section 12A, we were supposed to just file and get the certificate from mediation center and file that case in the court. So after obtaining the certificate physically, while we filed the hard copies of that case in the month of May, we filed that pre-mediation non-started certificate in the month of May. Objection was taken by the defendant saying that we have not complied with the mandatory requirement of Section 212A of the Commercial Act. So our suit is hit by Order 7/11, barred by the violation of essential mandatory requirement of Section 12A. So we were also struck and saying that initially because we mandated and we complied with all the requirements and there was confusion, but essentially we adopted and we complied with the directions of obtaining and doing the pre-mediation settlement as per the Commercial Act. But as the objection was taken, that was decided by the court, and then one of the judgment of the Supreme Court in Nova Automation Court case came out with the directions that whatever non-compliance defects were there in the non-compliance of pre-mediation, pre-instant commercial disputes prior to 22 August 2022 will be exempted from the purview and mandate of Section 12A. So by that the Supreme Court recently also in one of the judgment stepped in with the directions that though in some of the cases if they have not complied with the mandatory requirement of Section 2A going for the mediation, then all those suits to make it mandatory, so that because why I will tell you why this mediation clause was incorporated, and Supreme Court is of the view that why this requirement of essential mediation was kept in the Commercial Act. I will just tell you about it. Thereafter, the Supreme Court right now in last week has given the judgment that if the mandatory requirement of going to mediation facility is not obtained, all the suits, pending suits, they have to go to the mediation center, find the possibility of exploring settlement, and the requirement of complying with the Section 12A of the Commercial Court Act in the form of complying with pre-institution mediation is very much mandatory. Now I will tell you why this judgment has come from the Honorable Supreme Court, followed by the directions issued in 2024, saying that whatever non-compliance was there with regard to Section 12A of the Commercial Court Act was with the purpose that before going into litigation in the shape of arbitration, in the shape of traditional litigations, in commercial disputes, you have to avail the facility of mediation. So once you have not availed the facility of mediation, you can't go with a regular suit, you can't go with the regular suit in the arbitration. So now you can understand what is the requirement and the significance of mediation. I think you have understood what the point is I am discussing. So that means if you have not availed the opportunity and the facility of Section 12A of mediation, even you cannot file the suit. So see, the the significance of the mediation, arbitration, I have already told you. This is a mediation that I have just discussed with you with reference to the two judgments of the Honorable Supreme Court and the mandatory requirement of availing the mediation. So now you can understand in the context of even India how much importance has been given to all the alternative dispute resolution mechanism in the shape of arbitration, mediation, conciliation. Now coming to the conciliation. Conciliation is one of the important aspects in this branch of law, wherein if you are settling the disputes, even in mediation, in conciliation, if you are settling the dispute, you can have the degree that can be executed. And there you can also incorporate the clauses of penalty clauses. If you are not complying with the conciliation and the mediation, then you can have penalties incorporated in the settlements that can be executed. So it is not just to say that alternative dispute mechanism is not enforced by the penal provisions. ADR is enforced by the penal provisions which have been mandated by law with strict compliance. So now you can understand how you can choose the pathways for the ADR. These were earlier, these were non-weaponized before 2018-19, but in the context of world arena and the nations interested to invest in the countries where they can have their dispute resolutions, these mechanisms were evolved and still evolving with a fast pace so that an atmosphere can be given to the world community, to the multinational companies, to other countries, because what the other countries and the multinational companies and foreign investment in a country requires, they require that there has to be peace, there has to be stability in the provisions, there has to be the mechanism which can solve the disputes arisen between the business entities. So these are the ADR systems which have evolved, which were evolved, which are evolving in the present scenario. And I think if any of the business entity is even thinking in the light of now you have also heard one of the amendment that has been carried out by the Bar Council of India, and that's one of the important and very pivotal information that I am giving to you. If you are not having that, Bar Council of India has amended the rules for practice, in which it has provided, mandated that the foreign law firms and the foreign lawyers can practice in India. They can operate, they can open their office, except appearing in the court and taking part in the traditional litigations. But now you can see, if this kind of amendment has been carried out, have been done by the Bar Council of India, where we are heading to? We are heading towards the globalization. So, in a sense, if you are having good infrastructure in Delhi, a good team of lawyers, good team of ADR mechanism, good team of professionals, good team of even interns, I am saying so because in my office interns are also doing well, and we are also appreciating them. So if you have good infrastructure, you are able to convince the foreign law firms, you are able to convince the foreign lawyers that you have got good infrastructure, good team, good way of conducting the litigations and resolving the disputes, and all the mechanisms available. You are standing in a very competitive world, even while practicing in Delhi. So you can compete with the good law firms situated in US and Europe and Southeast Asia like Singapore, Hong Kong, Beijing, who are the hubs of foreign firms, foreign multinational law firms. So ADR in a sense is very important with the context of the present litigation. Now I will only touch the second topic of the intellectual property rights, which Ms. Neelam Pathak would be discussing in detail because she has been one of the hearing officers in the capacity of a judge. In trademark registry, she has dealt and heard the lawyers and the arguments and passed so many judgments. So in depth, she would be in a very technical way, will apprise you the pathways available on the issue on the subject of intellectual property. So in a short brief, though I can go on entire day or entire week stating about the benefits and explanation and more elaborating the provisions of ADR system, but given the the limitation of the time that we have, I'm just stopping myself up to this level, so that you can also raise your questions whether you want, or with regard to intellectual property, Ms. Neelam Pathak will be there with you.
Sir, there's a question from Mr.
Yes.
Online. He's asking what are high impact certification or training programs he can enroll as a 5th year student in ADR, which will help him in his career ahead.
ADR, there are so many ways of like you must be hearing about the patent agent and other trademark attorneys who are having the facilities of and privilege to file the cases, just like KOR. So if you are the patent agent in a particular field, then you have the privilege of being a person eligible and competent to take the litigation, to take the work, to get all the intellectual properties registered and do further litigations and advise the clients. Even the multinational companies are also looking after the professionals who are having the genuine and eligible license to do such kind of works. Any other question? Any of you? Thank you. I think I should call Ms. Neelam Pathak to address you further on the intellectual property in depth. Thank you.
Thank you all for giving me this opportunity to speak on the topic of the topic on IPR. My learned colleague has already spoken so much about the ultimate dispute resolutions on the topic of dispute resolution. So I will not go into that. I will directly come to the IPR, that is the intellectual property rights. If you say about the IP, that is intellectual property rights, by term it's clear that intellectual is the right which has been created for intellect. So in IPR, there are so many sectors that is completely, we say that trademark, copyright, design, and patent, and also GI, which including we can say all including we can say is intellectual property rights. There in IPR the emerging career is very bright for the new professionals in this profession. Suppose once I was there in the trademark registry as a hearing officials, where I had exposure of the IP litigations. Thereafter, I switched to the trademark registry for as a hearing official. So I have exposure of both litigation and the IP litigation also. So if the participants want to go for the career in the IP litigation is just like you want to secure your right as a trademark, then you have to file the application for securing your right, and once you get the registration for any trademark, then your right will be secure. Because in the business what happens, if after so many years once get the goodwill in any brand, and people are taking the privileges to getting the goodwill of any brand. So once you get the registration for any mark, for example, the Maggie, if I take the example of the Maggie, or in business, everybody wants to copy the goodwill of any mark. So if you to get the registration for any mark, then your right will be secure. And in litigation, there is a provision that you get the registration for any mark, then you can file for the infringement. But it is not only a limitation that you can have the registration, then you can file for the litigation. There are other provisions also without registration that your right can be secured for filing the passing of suit. So, in the litigation part, the lawyers wants to attain the degree and get the employment. You can say the IP is the means for them. It's can say that it's easy section, because the IP Act, the Trademark Act is a very small act. There are not much provision. So once get the expertise in the trademark, then the and other sector for the civil, matrimonial, and the criminal sector, we have to learn so many acts, so many things are there. So many things have to learn about the many acts. But in the trademark and the design act and the copyright act, very small act is there. So you can get the expertise within 6 months, or can get the expertise within 2 or 3 years. It depends upon you, how much time you will get. You will take. So it's good according to your interest and according to your situation, which both sectors are there. The IP prosecution is there, the litigation is also. It's depend on you where you want to. IP prosecution is also good as being the hearing officer. Its profession is quite good, because some guys don't want to go into the litigation, because there are lots of things which has to be handled. So in IP prosecution, that is not much thing, because only the application you have to get registration, and the opposition proceedings are there, and some guys strict only to the IP prosecution. But if you want to get the challenging field, then the litigation is the best, which I can say, because after the hearing officer, I'm completely involved in the litigation, because I can't stand without the litigation. So after getting the exposure and the experience from the hearing officer, I'm completely involved in the litigation. So my interest is the litigation. So it's all of you then which field you want to choose. Both are good according to your situation, according to your interest. And if I see career as a IP litigation, because it's everybody knows it's a completely commercial litigation, and all clients are the commercial corporate clients. So it's definitely it's a good paying litigation. And if the IP field, I want to say that the IP Act, it is globally, there is no only the minor modification. IP Act is only universally it is illegal. If you learn the IP Act, this is quite applicable in other countries also, like USA, Canada, and only one thing is that the countries are signing the TRIP Act. TRIP Act, that is if some country is signed that TRIP Act, then their right is also protected in the India, and our right is also protected in that country. So if you want to go in outer India also, then you have a good opportunity in the IT sector also, because there is not much. If the other field, if you see in other field, other litigation, then you have to get the diploma in that subject. But for the IT litigation, you have a good opportunity for the academic also, and you have a good opportunity for the litigation also. So there is nothing much to say in this intellectual property rights. So I have concluded that is the IP prosecution and litigation also, and you have a good opportunity for the academic in outer India also, and for the litigation you have already have a good option in India. And if someone wants to join the law firm, but also the law firms are getting the good opportunity, and the paying capacity is also good according to your from where you are getting the degree, and how capability you have. Because the law firm also, the 3 types of law firm, they are first type of law firm, from starting they are getting the good paying capacity, with 70 to 1 lakhs per getting. The 2 types they are getting 45 to 70, and generally the small shop they providing in the starting 25 to 40. So in the IP, for the purpose of the job in law firm, then you have a good opportunity in the job sector also, and you see that you can get the good clientele in the IPO sector, then the independent practice is the best option, and everybody prefer for this independent practice. No one wants to go for the job, so I have to give you all this. If you have any problem,
Could you also get how can students get internships in IPR firms? Since they are in their 5th year right now. So if they want to intern in any IPR firm.
there is no any hard and fast rule for getting the internship in the IPR sector.
As my firms are credible enough for internships and which accept interns.
IPR law firm there is a very values, Lal and Associates, Zan and Anand. But for applying there and internship, you have to first in advance you have to apply. They selected there after they get the opportunity to apply there. But there is no hard and fast rule to get the internship in any law firm. They are criteria, every law firm's criteria is different. No any diploma, no any certificates required to get an internship in any law firm which is specialized in that. Thank you so much.
If any participants have any question, you can ask in the chat box. Or you can switch on your mic and ask questions. If there are no further questions, I would like to invite Ms. Neelam ma'am for giving thank you note.
Good morning everyone. It is my privilege to propose a word of thanks on behalf of Legal and International Business School. Firstly, I would like to thank Advocate Amar, Saini, Senior Advocate, Supreme Court of India, and Advocate Neelam Pathak for sparing the time from their busy schedule to enlighten our participant on the topic of IBR and ADR. So, ma'am, your expertise, I'm damn sure that students have a great learning out of your great experience, and you have shared a lot of content and the lot of experiences you have faced in your course. Today's the IPR and ADR both have to be emerging field, and I think the students and the body lawyers have a great opportunity in this field. So I would like to thank both of you. I would like to thank all the participants and our faculty members for their patient listening. I would like to thank all the organizing committee for conducting such a great session, which can helpful for the future body lawyers.